What I wanted to do in this video is walk through a compromise and release and some of the issues that tend to come up from time to time. So you're an injured worker, you don't have an attorney, you've come to an agreement with either the insurance adjuster or the defense attorney to settle your case. It's going to be a lump sum payment. No future medical care will be left open, with rare exception. It's settling out everything. They're going to write one check. It will cover permanent disability, temporary disability issues, future medical care, your right to reopen. All of that will be wrapped up in the compromise and release. So what generally happens is the insurance adjuster or the defense attorney will draft that settlement document and they'll send it to you for your review and signature. What has happened in the past is that injured workers get the settlement document and they read through it real quick, they sign it, they send it back. When I served as a judge, I would sometimes get compromise and release with pro per applicant. And there were issues that I had where I couldn't approve the settlement as it was drafted. I would set the matter for a status conference. And when I spoke to the injured workers, I would ask, why did you sign the document with this language here? Do you agree with this language? And the injured worker would say, no, I don't agree with that language. We didn't agree on that. And I would say, but you signed it. You signed the settlement document with that language. And the injured worker would say, I didn't know that I could make changes. So here, you can make changes. What's going to happen is they will draft the document. It will almost certainly be favoring the insurance company in every way because they're the ones that are drafting the document. When it comes to you, it generally will not have any signatures on it because they're waiting to hear from you, the injured worker. You can read through, you can make additions, you can make subtractions, deletions, you can make changes to it, and then send those back to the insurance company or the defense attorney and point out what you did. Once everybody agrees on the language, then you'll usually sign the document and it goes to a judge for approval. But you do have the right to make changes to it before it goes into the judge. Now, once you've signed the document, then it is pretty much a final document. You don't get to make changes after you've signed it. Then it becomes a contract. But until that point, you can. So let's go through a compromise and release and go over some of the common issues. Starting at the top here, we have the case numbers, social security number. Make sure your number is correct. Venue will be listed wherever the case is being heard, usually near where you live. Employee, that's your information, name, your address. So it's important that you have your correct address here for two reasons. One, that's where they're going to send the check. So if you want to get the check, make sure the address is correct. Second, if it goes into the board and the judge can't approve it the way that it's drafted or has other issues as to adequacy, the judge will set the case for a status conference and notice will go out. But if the board doesn't have your correct address, you won't get notice of the hearing. So make sure that your address is correct. Oftentimes, people have an injury and it may take several years before you get to resolution and you've moved in that time. Make sure your correct address is listed. Here we have employer information, applicant's attorney, you are pro per, you don't have an attorney, so that will be blank. Here we have defense attorney, so either their attorney, if they have one, or if the adjuster created the CNR, the adjuster's name will be there and address. So that way the judge knows who is signing down below for the insurance company. The name of the insurance company, if there is one, and the name of the claims administrator, if there is one, will both be there. So the injured employee born, your date of birth, your occupation. There's not going to be a big fight there because you're settling this issue, so it's water under the bridge at this point, so it should just be your job title that's listed. Case number, if it's a specific injury, the date of injury. If it's a cumulative trauma, then it will have the start date and the ending date. We'll have the body parts listed. Generally, you're settling out all body parts. So anything that was pled, anything that came up during the case, those will generally all be listed in the CNR to settle out all issues. Injury occurred at wherever you were injured. There are options here for case number 2, 3, 4, and 5 on the CNR. So It could be that you worked for the employer for a number of years. You had, let's say, 3 relatively minor injuries, a little bit of treatment, got better. You don't work at the employer anymore, and now they're going to pay you some money to settle out both dates of injury. Those are all 3. Those will all be listed. Or if you got hurt at work, it was a specific injury, you went to a QME, and the QME said, part of the injury is due to the specific, but part of the permanent disability is also due to a cumulative trauma since you worked there for so long. Then in that case, you may be settling out the specific injury and the cumulative trauma together. I will note, the more injuries you're resolving at one time, the more complicated it gets. That's something that you likely will want to reach out to an attorney if you haven't done so yet, or reach out to Information and Assistance for clarification, just to make sure that we have adequacy covered since you're settling multiple dates of injury. Your earnings you were making, temporary disability that they've paid. So if it lists temporary disability that was paid, if you dispute that, now is the time to get clarification. Permanent disability that's been paid and when it was paid, again, if you dispute that, you need to get clarification, get a printout of benefits from the insurance company so that you can see the indemnity that's been paid. You have a right to that printout of benefits. Just request it from the adjuster or the defense attorney. Total medical bills paid. They may not put a number here. I believe it's generally in your best interest to get a printout of benefits showing how much medical has been paid. It may be that they didn't pay for much, but it may be that your medical bills were very expensive, and maybe now you're not settling for quite enough money if you actually knew how much the insurance company paid. So get that printout of benefits. You have a right to it. It simply allows you to make a more informed decision. Total unpaid medical is usually going to be not by defendant after the CNR is approved. So a CNR settles out everything. Once that judge puts his or her signature on the order approving, you're responsible for your ongoing medical, so the insurance company won't pay for it. So if the judge issues the order approving on Monday and you already had an appointment with your doctor and you go see your doctor on Tuesday or Wednesday, that case has been settled. It's going to be awfully difficult to get an insurance company to pay once that order approving has been issued. Scrolling down, the total settlement amount, so whatever you've agreed to settle with the insurance company. Now, here's an area that often causes confusion and frustration for injured workers. These are things that get deducted. The general rule is that permanent disability advances will get deducted from the settlement. So if the insurance company has been paying checks to you every 2 weeks for permanent disability advances, they may be $580 every 2 weeks. It might be less based on your earnings. Those will generally get deducted. That is the standard operating procedure in workers' compensation. Also deducted would be any temporary disability overpayment. If there is one, let's say you were getting temporary disability and you started another job and didn't tell the insurance company, then that would be a temporary disability overpayment because they were paying you benefits to be off work, but you were actually getting a paycheck. If that occurs, it needs to be spelled out down below in a box that we'll get to, and that will get deducted. I will also say that judges look very closely at temporary disability overpayments to make sure that it's equitable and appropriate in the instance of your settlement. There's a few other lines here. So let's say if EDD paid benefits and part of the reimbursement of the EDD is going to come from your portion of the settlement, then that would go in there. Or if you had a child support lien, that would get listed here as well because that's going to get deducted. Attorney's fee, the only way that might be an issue in your case, since you don't have an attorney, is if you had one previously. Then attorney's fees might get listed there, but otherwise that will generally be blank. And then this line, leaving a balance of, that's the total amount of the settlement that you are going to get. So that check that comes in the mail will be that amount, but it will be less any additional permanent disability advances. So you'll recall up here, let's say they had listed $2,000 for permanent disability advances through last week. There will be a date there. If they sent you another $580 check before the judge issued the order, that will get deducted as well because less further permanent disability advances after the date set forth above. So that will get deducted as well. Liens, if there's child support or the EDD, that should get spelled out there. Usually the insurance company will do the legwork on that one. They will generally be liable for any medical treatment liens, any doctor bills. If it's child support, you may need to get involved on that because it is coming from your portion of the settlement. Here you'll have initials. So you're going to initial anything that's being settled out. I will note serious and willful misconduct and discrimination, a 132A. You should not, I believe, initial those generally unless you know what they are or unless you've filed petitions and you're actively trying to settle them. What happens is a lot of the time there were no petitions filed for 132A or serious and willful, and the defense wants to initial those lines. However, if you don't know what those petitions are, then you shouldn't be generally initialing them and giving away your rights on those petitions because there haven't been a petition filed. It may be too late to file a petition. You may not have explored it. We have videos going into depth on what a 132A petition is and what a serious and willful petition is, but you need to get knowledgeable as to that before you're going to initial those lines. I also recommend reaching out to an attorney on those issues if you believe that there may be either of those petitions in the case. This comments box here, there, that is where you explain all of the settlement, what it's based on, the primary treating physician's report, the QME report, what the rating of the QME report was, what the anticipated future medical care is. If there's a temporary disability overpayment, that should be spelled out there, why there's an overpayment and why defendant is entitled to it. If you're not settling out an issue, so let's say the insurance company owes you for medical mileage for, let's say, 3 months, and part of your negotiation with them is that they're going to pay this CNR, but they're still going to pay you that mileage for those 3 months. That needs to be added in that comments box. If it's not, that issue is water under the bridge. It'll be settled out, and after the judge issues the order, the insurance company is not going to be liable for that because this document wraps up everything. So if there's an issue that's not being resolved, maybe they're going to pay for one more MRI appointment, they're going to pay for mileage, whatever it is, that needs to be spelled out in the comments box. Then we get to the end of the document. In the good old days, before COVID, you would sign, and at the same time, you would have 2 witnesses, or you would get the document notarized. We're still under the emergency regulations right now, so you don't need the witness signature, so it's just going to be your signature. You don't have an attorney, so it'll just be the attorney or the representative for the insurance company. You sign it. Everybody agrees on the language. It then goes to the WCAB, and a judge will act on it, ideally issue an order approving soon. If there's an issue, an order suspending will go out, and the matter will get set for a status conference. But that's a compromise and release in a nutshell. Some of the more common issues. If you have more questions on issues in the CNR, let us know. We can create a new video.